Okay, good morning, everyone, and welcome to the 9 o'clock section of Parental Alienation, Law and Practice. I'll begin by introducing our speakers and our presenters. For the first presentation, Parental Alienation Case Law Analysis from the Irish High Court and European Court of Human Rights, we have Andrew Doyle. Andrew Doyle is a postgraduate researcher in University College Cork, Ireland, in children's rights in high-conflict family separations. We also have Parental Alienation in Portugal, Between Evolution and Convictions by ECHR, Sandra Feiter, and I apologize if I'm not pronouncing names correctly. Dr. Feiter is an attorney with a PhD in law, and her legal scholarship focused on the topic of parental alienation. She will be giving a Zoom presentation. Next, we have How to Manage and Present the Legal Case Responsive to PA Dynamics, Parental Alienation Dynamics, by Brian Ludmer. Brian Ludmer is a skilled attorney in business and family law. His practice focuses on high-conflict divorce, parental alienation, and high-net-worth property and income disputes. Additionally, we have Researching PA as a Guardian ad litem in the Netherlands, and that's by Helene Koppejan Luitz. I apologize if I'm mispronouncing. Koppejan Luitze. She is a psychologist who has graduated cum laude on research on parental alienation. She is often assigned by court, either as a guardian, civil, or as an expert. Finally, we have The Child's Hearing and Its Importance for the Definition of Custody Regime in Parental Alienation Cases, Miriam Afonso Brigas. This is a pre-recorded presentation. She is an assistant professor at the Faculty of Law of the University of Lisbon since 2012, with a PhD in the area of historical legal sciences at the same university. Let's give a hand to our presenters.
I'll stay by the mic, I'll go with this one. So, good morning. I found yesterday fascinating, especially like some of Ben's stories and the different PA stories, and there was all different types of them. Mine's a bit different in that, yes, I'm a targeted parent, but I was a widower with a child before being then a targeted parent from a child from a second relationship. And, he talked about men's coping mechanisms, and we're very different. And when my wife died, the Cancer Society did bereaved parenting courses, and we found that the men's suicide rate's very high after losing partners, and we cope in weird ways. My way was I went out and got a pilot's license, which was a strange thing to do. And then when after the parental alienation and all the court cases, I decided I was going to go to college, because when I was younger I had to go to night school and doing an apprenticeship and so on. So this is my time to become a real student and live the student experience. And law was available, so I went and did that. So hello? How's it going on to the next one? There we go. So I've completed, I got a diploma in law, and then I got a bachelor in common law, and then I was admitted to do a PhD. Now, it does focus very much on the Irish family law situation, but it includes parental alienation in high conflict. And I'm looking at regulations, not just the children's rights and the law and how that works, but how it's implemented with the child protection, with the day-to-day elements and the healthcare and so on. This particular presentation focuses just on, I did a review of the case law in the Irish court, in the Irish High Court. The district and circuit court cases aren't reported there in camera, so it's very hard. You get very little snapshots of data from them. The European Court of Human Rights are applicable in Ireland, and I see a report on that, or a presentation on that later. So if I have time, I'm going to cover a couple of those. Later on, I'm also going to do some comparative, not at this presentation, with UK and Canada jurisdictions. And then my PhD will add empirical, quantitative and qualitative data by interviews. Just on the Irish context, first of all, so we model ourselves on the US because we're just over a 100-year-old country, but the Constitution is the source of all legislation and lawmaking capabilities. And we introduced an amendment to our Constitution, a new Article 42A, children, in 2015. So this brought in the rights of the child, and it made them imprescribable. So the legislators cannot take away rights of a child, or it will be challenged on a constitutionality basis. It also brought in the best interests of the child as being paramount. And it brought in how the voice of the child would be incorporated based on their age and their maturity. We had legislation ready to go with that, the Children and Family Relationships Act, and this is quite interesting reading if you're working in PA, where there's a section which is a checklist essentially for judges on what the best interests means. And number one on that is the child's relationship with both parents and grandparents and siblings and extended family, the great Irish family with the cousins and all the rest. So all these other people can be alienated. So there's a checklist there for the judge to go through. We're very poor on the regulation of experts. It was very loose. And the first step was a statutory instrument in 2019, which just says what type of experts can be used. But that is a long way to go yet. Then there is the United Nations Convention on the Rights of the Child, to which Ireland is a signatory and most other countries except the United States. So countries under that are audited every 5 years, and there is a process involving the child organisations in the country. So I got involved with an NGO and writing their submission for that, and had the pleasure of attending the United Nations in September of last year and again in January of this year, and taking some questions in front of the committee. Also, there's the Convention of, the Court of Human Rights and the European Convention of Human Rights, and we incorporate that into Irish law. Now, this is bigger than the EU. This is countries like Russia and Ukraine are signatories to that as well, and countries implement it in different ways. In Ireland, judicial notice must be taken of the jurisprudence of the decisions, so they do have effective law in Ireland. So I'll go quickly on to then the Irish case law and the Court of Human Rights case law. One context for the social legal context is that Ireland took over the rotating presidency of the Council of Europe last year, and we held an event in Dublin, and it was the Hear Our Voices, Rights and Best Interests of the Child in Parental Separation and Care. There's a link down the bottom there. You probably have to Google it because the link is in the presentation, but the whole thing is recorded. That's 7 hours, 14 minutes in, so you don't want to watch the whole thing. It's all 9 hours up. But Judge Daly, a family law judge, said the number of separations, he saw an 80-20 split on court cases that were resolved more or less by consent, and 20% high conflict, which had significant discord, mistrust, allegation and counter-allegation, all the things you're familiar with, and the contact and custody and access problematic, and children at the centre of the dispute. And as he said, these cases terrify me. Are the children being coached and I've no training to tell if they are? Are they living at one parent to the exclusion of the other and may have a negative view of the parent? The children, more than anyone, will have to live with the decision of the court. This was picked up in context as well we talked yesterday about COVID being the alienator's dream, so there was a lot of cases of that, and the main Law Society Gazette, the magazine for solicitors, ran a story about a mother using COVID-19 as an excuse to prevent access, and she called this a case of parental alienation. And if we do our mild, medium, severe, this would be on the mild, because the child wanted to go, the mother was just making it difficult. But they then mixed in the sort of estrangement and so on. And, that's sort of pushed over. But they said this was, they believe, the first reference to it in the Irish court. But they're wrong, because there was 11 more cases since 2011. So the Law magazine got it wrong. But the Department of Justice then moved on to do investigation of the concept, and they've reported on that. Then there was the Bar Review, and the Bar Review is the barristers who act in the higher courts, the folks in the black robes and the wigs and that. And they did a multi-jurisdiction report, and this made the cover of the Bar Review. But it cited all England and Wales cases, so that's EW's England Wales Family Court cases, and one Irish case on, my format's changed from on the Mac, sorry about that. And it didn't cite any of my cases either, and one case that didn't have parental alienation in it. The big news in the Irish context is we have Denise McCartan, who is a psychologist who has represented in cases as an expert and has a published book on it in the Irish context. As I was putting my PhD together, there was a similar one just finished from Northern Ireland, and it was about legal professionals' views on parental alienation, and that's online, you can read that. And then the Department of Justice did their open consultation. And it's ironic, they said, there's no agreed definition, and then they said, this is what it is. But I had the pleasure just the week before I came here of attending the Department of Justice, where they launched their 2 papers after much delay, a Parental Alienation policy paper and a Parental Alienation review of understandings, assessments and interventions. So it's the Department of Justice is talking about this. They're building it into the family law strategy. So when you hear the folks who say it doesn't exist, like it just does, there's no discussion really. Also, there's the Child and Family Protection Agency, TUSLA, and I've been in a consultation process with them for 3 years. They have 4 types of child abuse: neglect, emotional, physical, sexual, and this comes under emotional, and they talk about family conflict, but they're also changing their language in this to talk about coercive control and using children as a coercive control as being something that they need to step into and train people on. So May was a very busy month for us between the publications. The UK also built in parental alienation and coercive controlling behaviours as a means of alienating into their social workers checklist, the famous UN Special Rapporteur. And then another case came up which isn't in my set of documents because it wasn't in the High Court. I knew of the case, but it got a judicial review in the High Court, so it got reported. And the wording on that, they said the fact that the district court found in favour of the applicant on the merits of the complaint that there had been parental alienation on the part of the child's mother. So that was a district court now being reported in the High Court. So the easy way for a judge is not to go in and argue, is it real, is it not, and who agrees with the science. It's like, here's all your citations. You've got all your precedent. We move on to the next thing. There's also some published research on it where some other PhDs have sat in on over 1,000 cases that were in camera. And this is the Irish Journal of Family Law. If you look that up, and Roisin O'Shea did a good piece introducing some quantitative data on that as well. So then my cases, 11 cases. It's the High Court, so you have to be rich to get there. It's a small tip of a very big iceberg. But there are 11 cases going back to 2011. And the first one was 60,000 word judgment. Oh my God. I got swamped in that. Children from the ages of 1 up to 16. About half of them are Irish cases, which means they're within Ireland. And then Hague Convention cases is where a child is abducted across a border. So if they're abducted, they're inbound into Ireland, it's handled in the country where they arrive. So half of them were Hague cases inbound to Ireland. If a child is abducted out of Ireland, it's done in the other country. And then also there's 18 European Court of Human Rights cases. And the first one up there, IS and Others v. Malta, is a very accessible case. It's not too difficult to follow, very typical case, very easy to read, very important case. So I started hand coding this originally, and I've stepped back to do it as a PhD using proper tools to do it. But my hand coding, I looked at parental alienation. Was there a discussion in the court? What were the remedies? I looked at the voice of the child. Was it considered? Was it challenged? How was it incorporated into the best interests? Expert reports I won't look at today, or access breaches, but we look at some of the domestic violence. And just on the page 1 of that there, you see that the court was satisfied. Sorry, I can't read with these glasses, can I? The court was satisfied that whilst the father was clearly not without fault, the mother had alienated the children from contact with the father. In addition, the mother had set out to undermine and marginalise any expert who considered was giving evidence unfavourable to her. And it was a transfer of residence of one of the children, and the other 2 stayed with the mother. So it was very like the Canadian case talked about yesterday. So in where parental alienation was discussed, the court held that it did exist, and it was a factor in 64% of the cases. It deemed it didn't exist in 18%, and one where it said it fell short of the evidence required for full proof, and one was the judicial review that's not applicable. You have my database and some of the coding down the bottom there. This theory that it's introduced by abusive fathers, as Ben said yesterday, how ridiculous that is. In this case, it was introduced in 13% by fathers, 6% by mothers, 31% by experts, and 50% by the court itself. Now, there's a bit of double counting there because sometimes it was introduced by the expert and the court and not the parent. But the idea that it's fathers, not true, or abusive fathers, not true. And you see that there was some remedies, there was some transfers. Some of them were transferred into care, either permanently or temporarily. And there was even the one which fell short, there was procedures put in place to repair the relationships. So if we move on to voice of the child, and I just looked to codify how that was analysed. So there was child experts in 10 of the 11 cases. The exception was the judicial review. So one coding I found was that children had been briefed as to the desired outcome. So this was a case where a child was brought to Ireland from France, and the expert said he only had a black and white view of his father. The conclusion he drew was the child knew why they were coming to the assessment, and they'd have to find a reason for not going back to France. And he was surprised this was the only information. So I call this briefed. You were briefed what you had to say. There was another one where this was an alienating father, so they feared consequences, and the expert had met them once, and then when they met them the second time, the children were far more guarded, and they seemed to be in fear of upsetting their father or saying anything that might change his access. So he said it was very hard to determine what were the true voice of the child in this example. Then when children are coached, and you had something similar there a moment ago and something similar yesterday, in the very long case, the 2011 one, there was 9 experts viewed the child, and the mother one by one knocked them off. And expert number 7 was very favoured by the court. The child was getting on very well with them. And then the police arrived at his door and told he'd been accused of sexually assaulting the child. So he had to be recused from the case, and expert number 8 was brought in. And to protect the court process, they passed on the information from expert number 7 to expert number 8. And the judge demanded from the barrister that the mother apologise to the court for upsetting the process. And if you want a very interesting piece, you can read the judge's opinion on the apology that was not an apology. It's like almost 2 pages of him not accepting the apology. So the other one then was children giving incomplete or misleading information. An expert gave what seemed like a very good review where children had been brought into Ireland again, and they said they were really enjoying their new school, even though it was a different language. They were friends with everyone. They were getting on great. They loved their new house. But it turned out under cross-examination that they'd only been in that school for 4 days, and they'd only just moved to the house. So the expert was rather undermined in that case. So the voice of the child, we found that they were briefed, they feared consequences, they were coached, it was incomplete or misleading, and another one was unfair responsibility. Some children say, do you know what, I think the adult should decide, and I think that's a fair option as well. So just for time constraints, I'm going to move on to the domestic violence, and we looked at that as well. I looked at domestic violence, child abuse, and sex abuse in the case. And one of the judges commented that abduction is a form of child abuse, so they're potentially all child abuse, and they should be considered that way. Domestic violence was alleged in 8 of the 11 cases, and all bar 1 were withdrawn or struck out or vacated or dismissed. And maybe one of the lawyers can tell me the difference between those 4, but they seem to be all essentially the same thing. Child abuse or sexual abuse was alleged in 4 cases. 1 was partly upheld as rough parenting, and 3 sexual abuse allegations were dismissed, including the one against the expert. So again, just the graph on that really, to show you that only 1 there was a protection order put in place, but 10 of the 11, all the rest were vacated or thrown out essentially. And then that should say child or sexual abuse, that there was no allegations in 64%. So this idea that PA is being used to counter them is just 64%. There was absolutely no allegations made. And sorry, I've got the wrong glasses on now. Yeah, it was dismissed in 18% of the cases and dismissed against the expert as well. And there was only physical abuse in 9% of the cases. So this idea that, it's a factor in all of the cases almost, it bears up. The numbers are slightly different to the one shown yesterday. I think the Canadian example, it was like 1 out of 200, and I came up with 1 rough parenting out of 11, so a slightly higher incidence, and it is a small data set. In the European Court of Human Rights, and how am I doing for time? Have I got time to cover this? Yes. Okay, thank you. So there's 18 cases, and I'd advise you to look at Malta, and my supervising professor, who is really preeminent in children's rights going way back and worked with the United Nations, and she did this paper about 13 years ago, Protecting Children's Rights in the European Court of Human Rights, the Role of Positive Obligations. And I found this case, and I said to her, I'm going to do a case note on this, which she likes. So the court held the application was admissible. There was a violation of Article 8 of the Convention, and it invites the authorities to examine the applicant's situation speedily and take the relevant action without further delay, bearing in mind the findings. Now, it's not a court of appeal. when you exhaust your domestic remedies up to your Supreme Court, if you find that the outcome still violates your human rights, you can then go to this court, which can award you monetary damages, but it's more that it's naming and shaming the country. So if a country is mentioned in this court, then they tend to go and look at their legislation so they won't get caught again. So, and it applies to all of the countries. So a piece here just from paragraph 127, the court had already held that if a court was to base a decision on the views of children who are palpably unable to form or articulate an opinion on our wishes, for example, because of loyalty conflict and or exposure to alienating behavior of one parent, such a decision would run contrary to Article 8. So again, if you're going into court and there's an argument about does it exist or does it not exist, you've got all the citations from Ireland in this case and from superior courts, and you've got the European Court of Human Rights on your side talking about alienating and alienation behaviors. So what do you have to prove? You really don't. Now I go into a bit more detail in here than I really need to. I thought the slides would be out so you could read this in the notes afterwards. But I'll just read the piece here. There was one very interesting piece in paragraph 105. They considered the fact that access was supervised was necessary for the courts to make informed decisions and to ensure the children's well-being was given that they suffered from parental alienation syndrome. So they used the S word. You know. Now, it was the Maltese government that the court was quoting, so it's not the ECHR who was saying that necessarily. But here's syndrome in a 2020 case at the European Court, and it's not being denied. This is really a technical piece because it's saying about Article 8 was to protect the family from interference, and what they're saying here is actually it implies there is a positive obligation to protect the family. So you go beyond not interfering, and it uses a lot of case law references to do that. And it was saying that the Maltese, there was one person who was trying to talk. Am I on stop now? Okay. They said lack of cooperation between separated parents is not a circumstance which can by itself exempt authorities from their positive obligations. It rather imposes on the authorities an obligation to take measures to reconcile the conflicting interests of the parties. Again, interesting citation. I'll skip the next one. So what did I learn? Irish courts are dealing with parental alienation since 2011. It's all citable. The European Court of Human Rights since 2000. It's all citable, and it's not uncommon. And the data does not support the PA false allegations by abuser narrative, definitely. So I'm moving on to my PhD now, onto the rest of that. Thank you very much. Is there time for questions, or I'm just out of here?
Yes, but if there's a question from the audience, one or two,
okay.
You need to take the microphone or repeat the question, please. That's what you're asking.
Sure. Any questions? Yes, sir.
Question about whether the alienating parent is more or less 50-50 father and mother, which I think was shown in two surveys in Canada and the US. However, when I look at the cases from Europe, it seems that the great predominance of the alienating parent is the mother. Can you help me resolve that apparent contradiction?
It's a small data set. Mine's 80-20, but in Ireland, and it was like Ben said yesterday, in the UK, the resident parent in 95 to 99% of the cases is the mother. The father getting custody, prime custody, is very, very rare. So that would be reflected in that. But we were approached by an ombudsman for children when we were going to Geneva, who was from a Middle Eastern country, and there it's all the mothers who are alienated. The father takes the children. And then Japan is a very different situation. Don't have time to go into here. Thank you. Cultural specific. Thank you.